every single year, um, billions of dollars in these massive corporate disputes are settled, right?
Mhm.
And you will literally never see a single courtroom record of them.
Yeah, not one.
Exactly. No judges in black robes, no juries, no public dockets whatsoever. So, welcome to today's deep dive, where you've basically tasked us with decoding what is, the ultimate invisible rulebook for the global economy.
It really is invisible to most people.
It is. And the source material that you provided us for this is the ICC Arbitration Guideline for the newly minted 2026 rules, which actually just went into effect this June.
Right, and on the surface, looking at this document, it reads like a highly technical, super dry procedural manual.
Oh, totally. Very dense.
But when you actually examine the mechanisms inside, you realize this is essentially the operating system for international trade.
Yeah.
It's how the International Chamber of Commerce, the ICC, basically orchestrates private justice for the world's absolute largest companies.
So, our mission today is to figure out exactly how this hidden system works. We are going to, break down the mechanics of how these multinational disputes are resolved entirely privately,
Right.
including this brand new, highly expedited track that forces these massive legal battles to a final decision in just 3 months.
Which is just a fundamental shift in how corporations handle risk.
Right.
In traditional litigation, right, 3 months is barely enough time to schedule a preliminary hearing.
Let alone actually resolve a billion-dollar dispute.
Exactly, let alone resolve the whole thing.
So if you're following global business, you probably already know the basic reason why companies opt out of traditional courtrooms, right?
Sure.
Like if a Brazilian firm signs a massive infrastructure contract with some conglomerate in Japan, neither side wants to play an away game.
Right, nobody wants that home court disadvantage.
Right. The Brazilian company, they won't submit to a Tokyo court. And the Japanese company definitely won't submit to a court in Sao Paulo. So they agree on a neutral middle ground.
Yeah, the neutral territory.
But it feels like the real draw of the ICC isn't just offering a nice neutral conference room somewhere, is it? It's the enforcement mechanism.
Oh, absolutely. That is the core of the entire system. Because, winning a court case in one country doesn't actually mean anything in another country.
Wait, really?
Yeah.
Yeah.
So think about it. If the Japanese company somehow forced the Brazilian firm into a Tokyo court, right?
Yeah.
And they won, say, a $50 million judgment, they still have to actually collect that money.
Right.
So they take that Tokyo court order all the way to Brazil. And the Brazilian courts can simply look at it and say, we don't recognize Japanese jurisdiction here. Start over.
Oh, wow. So you could spend like 5 years winning a lawsuit, and at the end of it, all you get is a completely worthless piece of paper.
Exactly. It's a global enforcement nightmare.
Right.
But ICC arbitration bypasses that entirely because of this treaty. It's called the 1958 New York Convention.
Okay, the New York Convention.
Right. And under this treaty, an arbitral award is legally enforceable in over 170 countries.
That's huge.
It is. You take an ICC award to a judge in almost any jurisdiction in the world, and by treaty, they are literally obligated to enforce it. The local courts just become the muscle for the private tribunal.
So the ICC isn't just, offering a referee for the game. They are providing a referee whose calls are backed up by the enforcement power of global governments.
Exactly.
I can totally see why drafting this clause correctly into a contract is so critical. And looking at the guidelines for that drafting stage, the level of precision required is just staggering.
The details matter immensely.
Right, like you pick the city where the arbitration sits, the language, the number of arbitrators. But there was one hyper-specific detail in your sources that really stood out to me.
The China rule.
Yes. If your arbitration is going to be seated in mainland China, you cannot simply write ICC arbitration in your contract. You have to explicitly write out, let me get this right, International Court of Arbitration of the International Chamber of Commerce.
Yeah, it's a mouthful. But Chinese domestic law is notoriously strict about how institutional arbitration must be named to be legally recognized.
Really? Just over the name?
Yeah, if you just use the shorthand, ICC, local Chinese courts have historically viewed that as an invalid arbitration agreement.
Oh, no way.
Because it doesn't name a specific, formally recognized arbitration institution according to their Very precise statutory definitions.
That is absolutely terrifying for a corporate lawyer. Like, your entire billion-dollar safety net just vanishes over an acronym.
Pretty much.
It really highlights that while this system is incredibly powerful, getting through the door requires flawless execution.
And honestly, getting through the door is just the beginning. Once
Yeah.
you're actually in the system, the biggest threat to that legally binding, globally enforceable award is a conflict of interest.
Right, because if the referee is biased...
Exactly. If there's even a hint of bias, the losing party will immediately run to a local judge and demand the whole award be thrown out.
I
That is why the 2026 rules place such a massive emphasis on extreme transparency.
I noticed that. Like, Article 12 mandates that any prospective arbitrator must disclose anything, literally anything, that might call their independence into question.
Yes, and any doubt is resolved in favor of disclosure.
But what really jumped out at me is this new mandate around third-party funding.
Oh, this is a big one.
Yeah, parties now absolutely must promptly disclose if an outside funder has an economic interest in the outcome of the case.
Right, and to understand why, you have to think about how modern corporate litigation is evolving. Let's say a mining company in Peru is suing a contractor for $100 million.
Okay, huge stakes.
Right. But the mining company might not actually be paying its own legal fees. A massive hedge fund in London might be secretly bankrolling the entire lawsuit.
What an investment.
Exactly. They take on the financial risk upfront in exchange for, say, a 30% cut of the final winnings.
Which is wild, but that type of litigation finance is becoming incredibly common. Right?
Very common.
But why does the ICC care who is actually paying the lawyer's bills?
Because of the massive web of global financial relationships. What if the ostensibly neutral arbitrator chosen for this case is a senior partner at some big law firm in Paris?
Okay.
And what if that exact Paris law firm regularly does corporate tax work for that exact same London hedge fund?
Oh, so the arbitrator would have a direct financial relationship with the entity that stands to make $30 million off their verdict.
Exactly. And the crazy part is, they might not even know the hedge fund is involved if the funding agreement is kept secret.
Because it's hidden behind the mining company.
Right. But if that hidden connection is discovered after the fact, the neutrality of the entire case is completely compromised.
The whole billion-dollar case goes up in smoke.
It does. So by forcing the disclosure of any economic interest up front, the ICC allows the arbitrator to run a proper conflict check. It basically neutralizes the landmine before anyone steps on it.
Okay, so extreme transparency stops the award from being contested on bias. But what happens if the rules simply have a procedural blind spot?
What do you mean?
Like, you can't write a rule book that predicts every possible bizarre scenario in the world, right? Now, does a massive international decision get thrown out on a technicality just because the manual didn't cover it?
That brings us to Article 46. The 2026 guidelines highlight this as a general gap-filling clause.
Gap-filling. Okay.
Yeah, it is basically an acknowledgement by the ICC that they simply cannot predict everything. Article 46 dictates that if a procedural issue arises that is not explicitly covered in the rules, the tribunal and the court must act, quote, in the spirit of the rules to ensure the final award remains legally enforceable.
Give me an example of how that works in practice. Like, what kind of gap are we talking about here?
Okay, imagine a scenario where a tribunal issues a really strict deadline. They say a massive evidentiary filing must be submitted via a specific secure digital portal by exactly midnight.
Fair enough.
But at 10:00 p.m., a massive, totally unforeseen global IT outage takes down the portal.
Oh, like what happened with that huge airline outage recently.
Exactly like that. So the responding party is physically unable to comply with the technical letter of the procedural order.
And I bet the opposing counsel would immediately argue that the filing is late and should be completely excluded.
Oh, they definitely would.
Which could cost the other side the entire case.
Right. And in a rigid bureaucratic system, that might actually happen. But under Article 46, the tribunal has the explicit authority to look at the situation and determine that punishing the party for a global tech outage violates the spirit of fairness.
So they can just adapt.
Yes, they might accept the filing via an encrypted email instead. They fill the procedural gap in a way that prioritizes fairness and ultimate enforceability rather than letting some dumb technicality derail a high-stakes dispute.
Okay, handling those unexpected crises definitely keeps the process legally sound. But, it doesn't solve the other massive problem in corporate disputes, which is time.
Time is everything.
Right. Transparency and gap filling are vital, but prolonged uncertainty freezes capital. It stalls major infrastructure projects. If a dispute takes 5 years to resolve, that delay can honestly bankrupt a company, even if they eventually win the case.
Because time is the literal currency of business. And the ICC recognizes that exhaustive litigation is often entirely counterproductive. That's why the 2026 rules introduce this tiered system of urgent relief mechanisms to dramatically accelerate the legal clock.
Okay, let's unpack this. Let's walk through these 3 fast tracks. At the most urgent level, you have the emergency arbitrator, and the timeline here is wild.
It's extremely fast.
Yeah. A sole emergency arbitrator is appointed in just 2 days, and they must issue an order within 15 days.
So this is essentially legal triage. It is designed for interim conservatory measures.
What does that look like?
Imagine you discover that your supplier is about to load your proprietary patent technology onto a cargo ship bound for a rival manufacturer.
Oh, wow. Panic mode.
Complete panic. You cannot wait the standard month or 2 it takes to constitute a full 3-person tribunal. You need an injunction to stop that ship from leaving the port tomorrow.
So the emergency arbitrator stabilizes the patient, issues the immediate order, and holds things in place until the main doctors, like the full tribunal, can arrive to look at the entire breach of contract.
Exactly. It prevents the dispute from becoming moot before the actual case even begins.
Okay, makes sense. Moving up the ladder, we hit the expedited procedure, and according to the June 2026 updates, the threshold for this track just increased, right?
It did, to $4 million.
Right, so any dispute under $4 million automatically defaults to this expedited process. A sole arbitrator takes the case, and they are required to render a final award in just 6 months.
The mechanism here is all about proportionality. I mean, for a $3 million contract dispute, it makes absolutely zero financial sense to spend $2 million on lawyers arguing over discovery for 3 straight years.
It's just bad math.
Exactly. So the rules empower the sole arbitrator to aggressively streamline the process. They can limit the number of documents requested, they can limit the number of witnesses, or they can even decide to skip live hearings entirely.
Wait, no hearings at all?
None. They can judge the case purely on the submitted written documents.
So they can just say, hey, send me the PDFs and I'll give you a binding answer. No dramatic cross-examinations, no theatrics.
Right. It strips away all the theatrical elements of litigation to just deliver a commercial resolution.
Okay, that totally makes sense for smaller disputes. But the crown jewel of the 2026 rules is this brand new 3rd track, highly expedited arbitration.
Yes, this is the big innovation.
And this one doesn't have a dollar limit. It is entirely voluntary, meaning parties can opt into it regardless of how much money is at stake. But the mechanics here seem almost impossible.
They are intense.
Seriously. An initial case management conference must happen within 7 days. And from there, you have fixed 20 to 30-day deadlines to file your entire claim and defense.
No extensions allowed.
No extensions. No joining extra third parties. No consolidating it with other cases. And a final binding award must be delivered within 3 months.
3 months from that initial conference to a final global resolution of what could be a billion-dollar conflict.
Okay, hold on. If I'm a general counsel looking at a $50 million claim, a 3-month timeline doesn't sound efficient to me. It sounds reckless.
A lot of lawyers feel that way at first.
How do you compress 2 years of complex corporate litigation into 90 days without the arbitrator just, guessing? Like, if my legal team can't dig up every single email, depose 20 executives, and run forensic accounting, how do we actually find the truth? Doesn't rushing the process risk a completely sloppy verdict?
You've identified the exact friction point. And honestly, it's why the highly expedited track requires explicit consent from all parties to opt in.
Because it's a huge risk.
It requires a fundamental psychological shift from the lawyers involved. You are intentionally trading the pursuit of absolute perfection for absolute commercial finality.
So you're giving up that tiny chance of finding a smoking gun email in year 3 of discovery just to get the damn dispute off your balance sheet today.
Exactly. Think about what happens in that 7-day case management conference. The arbitrator sits down with these litigators who are totally used to scorched earth tactics, right?
Oh yeah, every trick in the book.
And the arbitrator tells them, look, you each get 20 pages for your main argument. You can submit 2 witness statements. There will be 0 requests for internal document production from the other side. You have 3 weeks. Go.
Oh, wow. So no digging through the other company's servers at all? You just present the contract, the invoices, and whatever direct communications you already have on hand.
It forces the parties to focus purely on the core commercial dispute. Like, did you deliver the steel on time or did you not?
Was the payment wired or was it not?
Exactly. For many companies, knowing the final answer in 90 days even if they end up losing the case, is just better for their stock price and their long-term strategic planning than fighting a murky, super distracting legal battle for half a decade.
They just stop the bleeding and get back to their core business.
That's the entire philosophy behind it.
It's a fascinating trade-off. But to enforce a schedule that ruthless, you need serious administrative muscle. And looking at the source document, there is a very strict dividing line between the roles of the court and the tribunal.
Yes.
Which is a common area of confusion, because when we hear International Court of Arbitration, we sort of naturally assume they are the ones listening to the evidence.
It is a legacy name, and it causes a lot of misunderstandings. The ICC court is not a judicial body in the traditional sense.
Okay, so what do they do?
Well, the court never reads the witness statements or decides who actually breached the contract. The court is purely an administrative oversight body.
Ah, they are like the ultimate stage managers for the whole process.
Exactly. The court manages the logistics. They formally appoint the arbitrators. They process any challenges if a party accuses an arbitrator of bias. And, importantly, they handle the money.
And then the tribunal is different.
Right, the tribunal, which is the specific 1 or 3 arbitrators appointed for that single specific case, they are the people who actually hear the evidence and render the final decision.
Okay, that makes sense. And the court is pretty militant about maintaining neutrality during that appointment process, right? Like, if the parties can't agree and the court has to appoint a sole arbitrator or the president of a 3-person tribunal, the strict rule is that the arbitrator cannot share a nationality with any party involved in the dispute.
They construct absolute structural impartiality. If it's a dispute between a Brazilian company and a Japanese company, like we talked about, the presiding arbitrator will likely be Swiss or Singaporean or maybe British.
Just someone with no inherent ties to either domestic legal culture.
Exactly. Complete neutrality.
Well, let's talk about the financial side of this, because this level of bespoke global justice isn't free.
Far from it.
Right. Just to open the door, there's a non-refundable filing fee of $5,000. The rules also hilariously note it's $6,000 if French value-added tax applies, which is just a very specific bureaucratic hurdle.
Very French.
Yeah. But after that initial filing fee, the way the ICC calculates the main costs is radically different from how you typically pay corporate litigators. They use an advance on costs system, which is essentially a massive escrow account split evenly between the claimant and the respondent. But the actual calculation is ad valorem.
Meaning the fees for the ICC's administration and the arbitrator's actual compensation are based on a percentage of the financial value of the dispute rather than an hourly rate.
Right. So it's the difference between paying a real estate agent a percentage commission on the sale of a house versus just leaving a taxi meter running endlessly.
That is a great way to put it.
Because the traditional model of paying lawyers by the hour inherently incentivizes them to, drag the case out. Every extra motion, every delayed hearing, it all generates more billable hours.
The ad valorem system fundamentally changes those financial incentives. The arbitrators get paid based on the size and complexity of the case, not how long they can manage to stretch it out.
Which, if you're looking at this from a business strategy perspective, that pricing model provides something invaluable: predictability.
Absolutely. Because the institutional costs are tied directly to the monetary size of the claim, a company's general counsel can literally go to the ICC's website, plug their dispute amount into the online cost calculator, and generate a highly accurate estimate of the arbitration costs before they ever even file a claim.
That's amazing.
You can run a precise cost-benefit analysis. You know exactly what the administrative overhead will be before you commit.
Treating justice as a predictable, fixed business expense is a huge advantage. So, okay, the advance on costs is fully funded. The tribunal has survived those insane fast-track deadlines, and they have finally reached a decision. They know who won.
Yes, the big moment.
Right. But before they hand that final piece of paper to the companies, the ICC introduces this quality control mechanism that I found genuinely surprising. It's called scrutiny by the court under Article 37.
This is one of the most unique and honestly vital features of ICC arbitration.
How does it work?
Before the tribunal is permitted to sign the final award and formally issue it to the parties, they must submit their draft to the ICC court for review.
Now, my immediate thought reading that was, wait, does the court overrule the tribunal?
That is a very common question.
Like, If the three arbitrators listened to all the evidence and decided the Brazilian company is in the right, can the administrative court step in and say, actually, we read the draft and we think the Japanese company should win?
Absolutely not.
Okay.
The court is explicitly forbidden from touching the substantive decision or altering the actual merits of the case. They are reviewing the draft strictly for form, internal consistency, and legal enforceability.
So what are they actually looking for during that scrutiny process?
They are essentially hunting for legal landmines.
Landmines.
Yeah. Imagine the tribunal determines the damages are $50 million, right? Plus a complex 5% compounding interest rate.
Sure, pretty standard.
But when writing the final draft, they make a mathematical error and list the final total as $58 million instead of $62 million.
Ouch.
If that goes unnoticed and the winning party tries to enforce $62 million, the losing party is going to challenge the discrepancy. And suddenly the entire award gets tied up in domestic appeals courts for another 3 years.
All over a typo. Or what if the court catches a failure to address one of the minor counterclaims?
Exactly. That could be grounds for annulment later. They check the math, they ensure every single claim was actually answered, and crucially, they check for mandatory legal requirements at the physical seat of the arbitration.
So they make sure the tribunal didn't violate some local procedural quirk that a domestic judge would later use to just throw the whole award out.
Precisely.
It's like having a team of elite legal mechanics inspect the engine of your car before you drive it off the lot. They don't care where you were driving, but they absolutely make sure the vehicle won't break down on the highway.
That's a perfect way to look at it.
And once it passes that scrutiny, the award is notified to the parties, the final costs are settled, and that is the absolute end of the line. The document dictates that the award is binding, and the parties are deemed to have waived their right to recourse.
There is no endless appellate process stretching on for another decade. You win or you lose, and the market simply moves on.
Stepping back to look at the big picture of these 2026 rules, the ICC really has managed a brilliant balancing act here.
They have.
Because they are offering extreme procedural velocity, like that crazy 3-month, highly expedited track, without actually sacrificing their core identity. They maintain unwavering structural neutrality, and through that intense scrutiny process, they deliver bulletproof enforceability across 170 countries.
It is a remarkable, totally self-contained ecosystem. And, there's one final detail tucked away at the very end of the source material you provided that truly illustrates the sheer gravity and respect this institution commands globally.
Oh, I know what you're going to say.
It's the concept of the ICC acting as an appointing authority.
Yes, I saw that. So what happens if two companies want the ICC's incredible expertise in vetting and picking neutral arbitrators, but they are actually using a completely different set of rules for their dispute, like, say, the UNC Citrol rules?
Right. So under most circumstances, an institution only ever administers cases under its own rulebook.
Makes sense.
But the ICC is so deeply embedded in the architecture of global trade that they will act as an appointing authority for ad hoc arbitrations, meaning parties using a completely rival framework will literally pay the ICC just to select the judges for them.
That is wild. It's the equivalent of, like, a rival tech startup renting out Apple's HR department because they know Apple is simply better at identifying and hiring elite engineers.
That is a perfect analogy. The ICC is essentially renting out its own credibility. Their mere stamp of approval on the selection of an arbitrator provides instant legitimacy to an unadministered ad hoc process.
It's an incredible flex.
It really is. Think about the immense soft power required to pull that off. It's something for you to mull over as you consider how global power actually functions behind the scenes, far away from the public eye.
It completely shifts your perspective. The next time you read a headline about a massive international merger collapsing or some cross-border supply chain dispute, don't picture the traditional, wood-paneled courtroom.
Nope, that's not where it happens.
Picture this invisible, high-speed, highly engineered system quietly sorting out the billions. Thank you for sharing such an eye-opening set of sources with us today. Keep seeking out that knowledge, and we'll catch you on the next deep dive.
Thanks for watching. Please subscribe and see you next time.